So let's move into the third and the final section for today. And this is going to be, we're going to take a walk through the legal codes on driver qualifications. And in essence, we're going to be dealing with 3327.10 and then three different sections of administrative codes. So here we go. We tend to, in our business, talk about, is a driver qualified or is a driver disqualified? And so that we can put that in context, here's the essence of it. If a driver doesn't meet all of the qualifications in revised and administrative code, they're not eligible to operate a school bus with students on board. So instead of saying someone's disqualified, the way the laws are set up on this is you have to meet all the codes before you're eligible to drive a bus. If you don't meet all the codes, you're not eligible. And so the second part of that is not only are they not eligible to operate a school bus, but going back to 4511.76, you as an employer are not allowed to have them operate a school bus with students on board. So that introduces a notion that you want to be very much aware of, and that is some parts of this qualification process the driver is responsible for. For example, they're responsible for their CDL. They're responsible for insulin waivers if they have that. They're responsible for follow-ups on medical issues. And so you could, as a supervisor, say, not my problem. We need to let the bus driver do that. But if the bus driver fails to meet one of those requirements, you also need to know that. And so as an employer, you have to constantly employ what we call due diligence to make sure that they meet all the qualifications, because that not only protects them, but it protects you. And so at the end of the day, we're all in it together, and we have to do what we have to do. So let's, I like to talk about this umbrella of requirements, and it starts at a federal level. So CDL is federal, drug and alcohol testing is federal. Some of the labor things that Van spent time going through with you are federal. And so those have to be followed. So those are the very root requirements. And then as we move down into a state and a local level, we add layers to this cake. So the base is always there. The federal thing is there. We cannot say, okay, we don't like CDL, so we're not going to use CDL for our school bus drivers. That's not an option. So the federal things always have to be met. The next set of requirements that we have to meet in Ohio are what we call the revised code. And so I just realized I have to turn off my phone. There we go. So the revised code is the next layer of requirements that we need to meet with. And when we're talking about personnel, for school bus drivers, we're specifically into chapter 3327 in the revised code. And there's a bunch of stuff in that, but the most important section is actually 3327.10. And that's where we set the minimum requirements for school bus drivers. OAC builds on them, but the initial requirement comes from the revised code. And so we build on the federal, and then we add the state revised code, and then the administrative code. So none of the lesser codes can disregard something that's already in place. So we have to start somewhere. So for today's session, we're going to start with 3327.10, and then we'll finish up in OAC where it adds the finishing touches to it. So very first thing that we run into in 3327.10, and you'll see through the next couple of slides, there's some letters next to the item we're going to talk about. That is the actual letter from the section of code. So if you wanted to look it up, and I have provided this to you as a handout. The handout also has annotations on the bottom that in essence speak to the same things we're going to talk about today. And by the way, in our next class, which comes up, let me look at the date real here, on December 2nd. December 2nd's class is our annual rules and regulations course. And so we'll touch a little bit on some of these things, but because we're dealing with personnel today, I might touch on them lighter than we normally do, and we'll focus on other issues. But you'll get another set of handouts coming up in a month that's got some of the same materials in it. So the employer's annual certificate is a requirement, and that has to be issued annually. The bottom line is that someone on behalf of the employer, so that could be the superintendent. If there's a contractor, it could be the contract manager. However, the district also has to issue a certificate, and that certificate is generated once a year saying that the driver meets the minimum age requirements, and in the revised code it's 18. We'll talk about administrative code, which actually raises that. They meet all the driver qualifications and they're of good moral character. So that language has been in place for quite some time. Good moral character is not a very definitive statement, and I think you'll agree with me in saying, okay, different people could define that differently. So what has happened since then is we've introduced a requirement for criminal background checks, and you'll see that come in here later in this very section of revised code, and then it's fully amplified and introduced in the administrative code. So even though we've got a broad statement here, it does get more detailed as we move forward. So here's the most important thing about that annual certificate is that once you issue it, as an employer, you have the right to revoke it. So that's an important distinction. And if you never issue that annual certificate because of oversight, or that's not been your practice, first off, you're not compliant with the law. But more significantly, if you haven't issued it, there's no way to revoke it. The significance of revoking that certificate is that driver is no longer qualified to operate a school bus with students on board. And if you go back to the last slide, what happens if they're not qualified? They're not allowed to drive. And so if they're drivers and there's problems and they've let their physical slide or their CDL slide, one opportunity for managing that as a district is to revoke their certificate until the problem has been resolved. So that may mean you need to work with the Van Keatings of the world, get attorneys to the table and figure out, okay, so what's this driver's status? Are they on leave? Are they absent without pay? Do we terminate? Do we rehire? Those are all local decisions. What the law says is they can't drive a bus with students on board. Second thing we run into in 3327 is the physical requirements. Now, what this section of code says is that annually a school bus driver has to take a physical. It doesn't say what the physical requirements are, but what it does say is who's allowed to provide the exam. That doesn't give the drivers carte blanche to pick who they want. As you'll see when we get into the administrative code, we restrict that once we get in there. But what it does is provide a list of folks for districts to choose from when it comes time for the school bus driver physical. The next thing that shows up in 332710 deals with driving records. And we have an interesting clause in here that requires drivers to self-report traffic convictions or license action to their employer. Yes, you're right. We do driving records checks, and we'll talk about how often we do those and how we do those. So as an employer, you're doing those checks, but that's a form of due diligence. Actually, what the code says in 332710, section D, is that drivers are required to report in writing to the superintendent or superintendent's designee if they've been convicted of a traffic conviction or if their license has been suspended, revoked, or it's expired. They're not allowed to drive until they filed that report. So I've heard drivers, supervisors in districts say to their drivers, well, you have 10 days to let us know, or you have 30 days to let us know. That's not what the law says. What the law says is you're not allowed to drive until you filed a written report with your employer. So there's really no number of days involved there. The fact of the matter is, if you are convicted of a traffic violation, you need to let your supervisor know immediately, and you have to do that in writing. Now, what many districts do is they amplify this, and they say, okay, drivers, here's our practice. You are required to notify us when you are issued the ticket. That's not the conviction point. The conviction point is when they sign the ticket, plead guilty, or show up in court. But what most districts do, and I would encourage you to really think about how to get this into play, is to require your drivers to tell you when they get a ticket. Failure to report. So if a driver forgets to let you know they got a speeding ticket and pled out, that is grounds for certificate revocation. So again, an employment certificate that you issued, you can revoke it if you find out when you run your background check that they forgot to tell you. It's also a minor misdemeanor. So it's also a crime, and they can be charged with a minor misdemeanor and they would be guilty. The next thing that shows up in revised code is in paragraph E, and there's an awful lot of language inside the revised code, but it really boils down to a fairly simple thing. Each employer is required to perform a criminal background check on all individuals that apply to be a school bus driver. So you have to do that when they apply and before you hire. So what's that mean? Well, that means you have to submit for the state and FBI background check, and you have to have the results of that check back, and you have to review them before you're allowed to hire that individual. Once you've done the initial screening, and if it comes back okay and you hire them, you're then required to repeat that every 6 years. And the way we manage that in both the administrative and the revised code is that we do new criminal background checks with every school bus driver certification. So drivers recertify on a 6-year cycle. That's when you would do your background check. Now here's a very important note. The background check has to be done through a BCI. I know of cases where, especially in the big cities, where a prosecutor or somebody on behalf of the mayor's office has said to school districts, hey, we'll run these things for you and we won't charge you a penny, we'll give you what we have. Those are not satisfactory in the eyes of the law. The law says that for school bus drivers, and that includes van drivers, is you have to run this background check through the Bureau of Criminal Investigation. So that's the only place you can get it. We had a very notable case that actually occurred with a contractor that was serving Columbus Public Schools back in 2009, where we discovered that the contractor had done their background checks through the sheriff's office and they had not gotten all of the state records, and none of those checks counted. So know that you do have to do this through BCI, and sometimes those results are not returned very quickly. So this is probably one of the first things you want to do when you talk to a new applicant. For new applicants, both a state and an FBI check is required. So that FBI check, that looks at national records. That can be waived if an individual can prove to you that they've been an Ohio resident for 5 years prior to the check. So if it's a new applicant and they can prove that they've had an in-state address for the last 5 years, you don't necessarily have to run that FBI check. Now, as an employer, you might want to anyway, especially if you know an individual came from out of state at some point, because the only way you're going to see something happen in another state that might be significant and have some bearing upon whether you're comfortable with this person controlling and managing students, you might want to run that FBI check even though you don't have to. So here's an interesting clause. The second point on this slide is that if you have somebody apply to work for you and they say to you, well, I just had a background check done and you don't need to do it again. So there is a provision within BCI standards, and it's supported in administrative code, that if an employee, an applicant, can provide you with the letter of results from BCII, and it's less than 12 months prior to the date they applied with you, you can accept that in lieu of doing a new check. All right, so that's the only time you can say to somebody, okay, we can accept that letter if that check was run less than 12 months before the date that you're intending to hire them. Now, this all you know, when we say we get these things back, and this goes back to this first paragraph in section A of the section of code says you have to be a good moral character. Well, what defines that? That's now very tightly defined within the terms of Ohio Administrative Code 3301-83-23. And we'll get to that a little bit later here when we go through these slides. So when you get the results back, there is a standard for you to look at to compare them to. In the code, it is specifically written that individuals who do not meet the standard as set by ODE, so that's in Rule 23, may not be hired, or if they're already hired, you have to release them from employment. Okay, so if they don't meet the standard, you can't use them. So the records check also sets something else up, and this has changed. We initially set this up when I was still working for the department, and the procedure has changed a little bit, so we'll talk about what happens now. There's a process that's called wrap back, and wrap is an acronym. It stands for Retained Applicant Prints. So BCI, as you may know, or perhaps not, all their background checks are done through fingerprint scans. And so when an individual goes for a background check, what they do is they have their fingerprints taken. Those then become part of a permanent file at BCI. And anytime they have an individual has an encounter with law enforcement at any level across the state, what it does is if they get fingerprinted again, which is supposed to be what happens, then that generates a file check back with BCI. And so under wrap back, BCI on a nightly basis scans all the records in their system. So anybody who's got a record in their system because they had a criminal background check and they're marked as a bus driver or a school van driver, there's a live database for those individuals. And if they get arrested or convicted of anything across the state and BCI knows about that, BCI reports that to ODE, and then ODE's responsibility is to notify you. Now, the way we originally set this up was BCI communicated directly with the employers. I understand that's changed in the last 5 years. BCI now only reports to ODE, which means you are 100% dependent upon ODE letting you know if something happened to one of your drivers. So I share that with you because I want you to know that wrap back is a nice insurance policy, but it's not 100% complete. First off, there are some municipalities in the state that don't fingerprint individuals when they're arrested. And if they don't fingerprint them, then nothing goes to BCI. BCI won't find what they call a hit in the database, and BCI won't notify ODE. And if ODE doesn't know, then they can't notify you. The other thing is that there have been some cases where ODE was notified and they didn't necessarily do a timely job of notifying the employers. So the reason I share this with you is to say, as a school bus driver or a school van driver employee, you also need to maintain due diligence. Be aware of what's going on around you. Listen to rumors you may hear. I know I worked in one community where there was a local newspaper that came out every Thursday, and there was a column in there called Judy's Jabber. And you could read anybody who was arrested in the last week. And so if you have something like that in your community, I would encourage you to monitor it and keep track of these things any way that you possibly can. There's an important section that actually I'm pleased to say that I had some legislators work with me on this back in 2005, and it's now part of the law. And I want to share this with you and put it in front of you because it gives you some powers that not everybody knew you had. And what the law now says is a person, school district, educational service center, community school, non-public school, or other public, non-public entity, in essence, anybody that owns a school bus or a motor van or contracts with somebody for school bus service and van service, you have the express right to impose more stringent restrictions on drivers than those that are prescribed in this section, any other part of revised code, or in rules adopted by the state board. Right here is what you need to keep in mind if you're sitting down at the bargaining table, your operating procedures, figuring out how you're going to do business in your school district. The bottom line is that you have the authority under law to say, here's what we're going to do. Sorry, I had accidentally turned off chat, so I just kind of turned it back on here so that I can monitor what's going on. Somebody asked for the template for the certificate. Let me take just a minute to say to all of you as an MTA participant, you have access to a bunch of online resources on our website, and one of those is a forms library. And so if you go to that forms library, you will see some examples of certificates that you can use. There is no state prescribed form, so you can create your own certificate. But take a look at that forms library when you get a chance. Not now, let me finish my class first. But take a look in the forms library, and there's some great stuff in there. So that's all I'm going to cover in revised code. But now let's talk about what is administrative code, what is revised code. Well, revised code is adopted by the legislature, so the senators and representatives, and then signed into law by the governor. Administrative code's promulgated, in other words, written by government agencies. So in our case, the pupil transportation operation and safety rules are written by the Ohio Department of Education. Those rules actually belong to the state school board. Right? So they are state school board rules. They are reviewed by the legislature, and then they're adopted. They are, even though it's called an administrative code, it is law. So it's not optional. This is not one of those stop signs with the optional ring around it. Both administrative code and revised code are law, and you have to follow them. Technically, the words that we use when we describe administrative code is that it amplifies revised code. So it takes something that might be a broad concept in revised code, for example, of good moral character. That's a pretty loose comment. And what the administrative code does is it amplifies it. It says, okay, here is how we define things that are not of good moral character. And so if a driver has been found guilty of one of those things, they're no longer qualified to operate a school bus. So let's jump in. The very first rule I want to talk about is 3301-8306. This is in general the personnel qualifications rule. Inside this rule, you'll find discussion about supervisors, bus drivers, van drivers, OBIs, and mechanics and technicians, and there's a section in there about bus aides also. So the very first thing I want to point out to you is inside of this rule, we specify the minimum age for a student transportation driver is 21. This has been the case since 2012. We have had a couple of administrators at ODE that didn't understand how law works, and they were telling district it's okay to hire someone who's 18. It's not. The law very clearly says the minimum age for a student transportation driver is 21. Now you might say, well, I think the revised code says 18. Well, what the revised code says is they have to be at least 18. And what we do in administrative code is we step that up and say, okay, they're at least 18, but here we're saying they also have to be at least 21. And that's no different from any other section of administrative code, which amplifies the requirements. If you want to know why we use 21 instead of an 18, if you think about insurance and loss rates and liabilities, those of you that have had children of your own that have grown up know that when you first get them a vehicle license and they're 16, 17, 18, and 19, insurance premiums are really high. The reason they're really high is because there's a high loss ratio. And we see the same thing in a school bus. You know, we've had actually two states in the country for a while that allowed 18-year-olds to drive school buses. And so there was a very weird dynamic going on where you had teenage boys driving the school bus, taking teenage girls home in the bus and making dates on the way. And that's, you know, there's no way you can have an 18-year-old child, if you will, behind the wheel of a school bus, managing all that responsibility, handling their fellow classmates in the back of the bus. So we use a minimum age of 21. That's consistent with what the insurance companies are looking for in CDL operators. And so bottom line is, if you're not 21, you cannot drive a school bus or a school van in the state of Ohio. You could if you go to South Carolina. These individuals also must pass a physical, and the physical we'll define here in just a second. And semi-annual driver record checks are required. So this goes back to, remember section D, 332710, there's a driver self-reporting thing. There's another section within that code that says as an employer, you're required to also check their records to make sure they're self-reporting to you as they should. So what we amplify here in the administrative code is you need to check the driver's records at least twice per year. And you must do it through ODE's web system. So what we engineered back in 2009 is we created a link between the state BMV office and ODE's web system so that you can now see a driver's driving records directly through SFPS. No longer do you have to fill out a form called an abstract request and send it to the registrar to get the results back. And the biggest reason why we changed that is when you send those forms back in and you do it through the registrar, you're only getting a 3-year driving history. That doesn't work in a state where we require you to look back 10 years for records of an OVI. So what you're now getting through ODE's web system is a lifetime driving record check, albeit it is 24 hours old. So you need to know that there is a 24-hour delay between what BMV posts on their records and what shows up when you log into ODE's web system. And I just want to make a note here as a practice. This is free. It doesn't cost you a dime. If you're only running these driver's checks twice a year, you're missing an incredible opportunity. There's no reason why you wouldn't run this check once a month just to make sure that all your drivers are doing what they need to do to keep operating as a safe school bus driver. So what do you look for when you get the driving records? By the way, when you run that report, you can run it for an individual driver, or there is a way to run it for every driver that's in your database, so that you get a long list. You do need to create this written report at least twice a year and keep it in a file somewhere. That satisfies the records audits. When you look at the results for any individual driver, you need to look at a couple things. First off, you need to look at points and offenses. We have in the administrative code a clause that says a driver can have no more than 6 points in the past 2 years. So this timeline is very important to understand. In BMV's driver records, once points are assigned, they're always listed. So points don't drop off the record. They're always listed. Points, however, are not considered to be current unless they're within the last 2 years. So the very first thing you need to look at is to look at that driver's abstract, look at the dates on there, and count up how many points they had in the last 2 years. If they have 6 points, they're at the limit. If they get something else, they can't drive until the 2 oldest points drop off. Right? For an OVI or a similar conviction, if they have been found guilty of that, that goes back 10 years. So they're not eligible to drive a bus if they have an OVI in the last 10 years. And then there's another line in there that says they cannot have 2 or more serious CDL violations in the last 2 years. And that's a little bit harder because one of the serious CDL violations is speed in excess of 15 miles an hour over the posted limit. That doesn't always show up when you look at that abstract when you print it out. And so here's a case where if you have a driver that shows speed, you may have to ask them for a copy of the citation, or you can also contact BMV and say, I'm an employer, I need to know more details about a particular violation to find out if it was a serious CDL violation or not. And then we have another section in Rule 6 that says drivers cannot have been guilty of a railroad crossing violation in the last year. And so the interesting thing about that is The way we wrote the language on the railroad crossing, and I was involved in this when we put it in there, is that may not necessarily show up on the driving record. If you have any evidence that an individual violated a railroad crossing in the last year, whether it's a report from the railroad, video camera from the bus, that counts. And you can disqualify them for the last year. Deb asks, is there a list of serious CDL violations? Yep, hold on, we'll get to it in the next slide. But back to the railroad crossing thing, know that, and we were very specific when we wrote the language on this, because there are cases where you may know that a driver has done this. You may get a report from a railroad. There may be a local security camera there and you watch it. And if you see that happen, that is grounds in 3301, 8306 for you to disqualify, and you should and must disqualify that driver from driving a school bus for the next year. What are the major CDL violations? And some of these, you'll look at these and think, oh my gosh, this is bureaucracy at its worst, and it might be true. If you are stopped and you're driving a CDL vehicle or commercial motor vehicle, and you're not able to produce your CDL because you left it home, that's considered to be a major CDL violation. 15 mile an hour over the speed limit is a major CDL violation. Assured clear distance, sometimes we call that ACD, or following too closely. Improper lane change, and keep in mind, these are targeted around commercial motor vehicles, which are, for the most part, semis on the highways. And then the other one is operating without an appropriate license and endorsement. So this is a technical thing. I want you to watch this last one, and I will tell you that in my years as a supervisor, every time I sent a driver to get their CDL renewed, I would tell them to come back to the office and let me take a photocopy of it and put it in their file, because you want to make sure when they come back from the BMV that they still have their S and their P endorsements, and that it's still the right class vehicle, whether it's a B or a C, and that there's no restrictions on there. You don't want to accidentally have an air brake restriction show up when every bus you own has air brakes on it. So these are things to watch for. And again, they won't necessarily show up on the driving record. So again, obviously improper lane change will, ACD will. Speed is the tough one, because when you see speed on a driving record, it'll simply say speed, 2 points. Sometimes 3 or 4 points if it was high enough. If it's 3 or 4 points, that means it was a fairly egregious incident. And you can probably safely assume that was more than 15 mile an hour over. Here's an important point. Remember that section of revised code I showed you that says you can implement your own rules that are tougher? You can set the bar higher. In your district, you may choose to adopt a policy that says 4 points is the limit, not 6 points. So you can set a higher standard. Lori's question, are these major violations obtained while driving the bus, not your personal vehicle? So here's an interesting, that's a great question, Lori. And on all these things, let me say to you that any violation that a driver earns is considered valid. So we're not looking just for tickets they got driving in a school bus. We're looking for tickets, citations, violations that happened in anything they were driving. If they were on their motorcycle, shoot, if they were riding their motorized bicycle down the road and get a ticket, you need to look at the violation they were charged with. In all likelihood, they're not going to be charged for a serious CDL violation unless they're operating a commercial motor vehicle. That's not to say there wouldn't be a case where law enforcement would do that. So when we talk about serious CDL violations, we talk about certain violations. So ACD, whether it happens in a CMV or not, is a serious violation. Improper lane change in any kind of a vehicle is a serious violation. Probably not carrying the CDL or not having the CDL endorsements, right? That's not going to happen if they're not in a commercial motor vehicle, but the other things certainly are. So you need to watch these things all the time. And by the way, you could very well have a driver come to you and say, well, I didn't tell you about that speeding ticket because it happened in my car, not in a school bus, so it doesn't count. Wrong. It counts. They all count. Here's the most important thing that I want to share with you before we move on. When you look at driving records, I want you to look at patterns. And I know everybody's short for drivers, and it's really sad when we get to the point and the only qualification is you stick a mirror in front of them, and if they can fog it up, you say, okay, you're hired. But when you look at driving records, you need to look very carefully. They might be below the limit on points, but they might have a crash and a speeding ticket every other year, going back 10, 15 years. If you look at violations, citations, and points that are on their record, and you see that there's a pattern that has not been broken, it's probably not going to change after you hire them. And you can expect more of the same. And think about, okay, do you want that to happen when they're driving one of your buses with students on board? And, you know, how do we address that in the community when a crash happens? How do you explain that to a child's mom? Because you know as well as I do that when there's a school bus driver involved in some kind of an incident and the school bus driver is found to be wrong and someone gets hurt, they start uncovering every little piece of dirt they can find. They turn the rocks over, the newspapers get involved, the press starts sending their I-team out. And so you kind of need to think about not only what's right for the kids, but how do we protect the district and protect yourselves? This is part of due diligence. This is part of the background check that you need to do before you hire someone. So if you see a pattern that looks dangerous and it's not changing, don't expect it to change after you hire them. So what about that CDL license? So it's the bus driver's responsibility to maintain a valid CDL with appropriate endorsement. They also have to have a current employer certificate. We talked about that. But they also, school bus drivers and van drivers need a current training certificate. So for us in Ohio, we call that the T9. They have to have a satisfactory criminal background report. And we'll get to that. There's a whole rule just on that. And the drivers are required to participate in DOT drug and alcohol testing. So that's as far as the administrative code goes. And the reason the code doesn't go any further than that is because the DOT standards are federal standards. And so they're not restated in Ohio's law. Ohio's law simply says you have to participate. The feds say that also. But we don't want to put all the details about, you know, what the testing levels, frequency, when you go, how you go, who reports it, who takes you. That's all addressed at a federal level. The law simply says in Ohio, drivers must participate. So you get your list of names from your DOT testing provider, and they say, okay, here's the drivers you need to send down for their randoms today. And you call Jane Doe into the office, say it's your day to go test. And Jane says, I don't think so. I'm not interested. At that point in time, she no longer meets the qualifications for a bus driver in Ohio because she has not participated in the DOT drug and alcohol testing. And you can no longer retain her as an employed school bus driver. Right? So she hasn't failed the test, but she's failed to participate. So you now would terminate them based on the fact that she no longer meets the qualifications in Rule 6. There are a couple of other driving record disqualifications. They don't show up in Rule 6. They show up in Rule 23, but I want to talk about them right here while we're in Rule 6 because we're still talking about driver records. A driver that is charged and convicted of reckless op or driving under suspension or having physical control under the influence within the last 6 years is not eligible to drive a school bus. Right? And then the other thing that shows up in Rule 23 is any school bus driver or van driver that's convicted of passing a stopped school bus or convicted of a school zone speed limit or railroad crossing violation within the last year is no longer qualified to drive a school bus. Right? So in some cases, this school zone violation here in Ohio, that lots of times that's become a civil penalty. So that may not show up on the driving record, But if that happened in your town and you know, the council or the village had set up a speed thing and they're now handling it as a civil crime, that's still a conviction. And so that individual is not eligible to drive a school bus for the next year. A couple more things on CDLs. It's the driver's obligation to keep an up-to-date license. So it's not your job, but you might want to protect yourself by keeping a chart ready and letting folks know, hey, your license expires, you need to go get it renewed. If you're monitoring your emails, ODE has an automated system that will send you an automated reminder through SFPS 7 days before a driver's CDL expires. And then they'll send you another one on the day the license expired saying Jane Doe is no longer eligible to drive. You can monitor that self by creating your own Excel spreadsheet and just keeping track of it. Once a CDL is expired, the driver is no longer eligible to operate a school bus. Now, they may say to you, well, it just expired yesterday. I have 60 days to renew this. Well, they have a certain amount of time to renew it without having to retest, but it's an expired license. They're not eligible to drive a bus. So you have to sit them down, send them home, tell them you need to solve this problem, and you can't drive or be an employee again until you can prove to us that you have a valid license. All right, physicals. So there is a list of who's allowed to do physicals. That comes from 332710. And then in 3301-8307, what the code says is the district annually appoints one or more eligible licensed individuals to perform exams. So that means the district has to pick from the list in 332710, and then you tell your drivers, here's where you go for your physical. And this is very important. You don't want the drivers to pick their own physician, because then you're not getting an objective physical. When you send your drivers for their T8, you want that physician or licensed examiner to be working for you and not the driver, and not to have conflicting goals. If that driver goes their own personal physician, two things can happen. One is they may be a little reluctant to not qualify them because they don't want to put in, you know, a customer out of work. Second thing is, not all personal physicians and individuals that don't do T8s know what the requirements are for driving a school bus or a school van. And so you want that individual to be working for the district and not for the driver. The results of the exam must be entered into SFPS by the district. And so this is the biggest technical issue that we have with physicals, is that as a supervisor, you'll send your drivers to get their physical. You get the form back, and then you put it in a drawer and you forget about it. You actually have to enter that information into ODE's SFPS system so that they can update their records and the driver won't get automatically disqualified. So here's the timing on physicals. You have to have a physical for each school year. And so you can start sending your drivers for physicals after May 1st, and they have to have it done before transporting students in the new school year. Now, ODE defines a new school year as August 31st, and they do that because the system automatically sends out warning notices on August 31st. On September 1, every driver in the system that doesn't have an updated physical, it generates a warning notice to the district saying, hey, this driver is no longer eligible to drive a school transportation vehicle. That's not a problem for you if they haven't started driving yet, but before they do start driving, you'll have to update that. Now, there's one exception to this time frame, and that is if you hire a new driver after January 1st. So let's say this year we're in right now, you hired somebody on February 1st, you trained them, you sent them for a physical. That physical remains valid through the next year. You don't have to turn around 3 months later and send them back. Now, just a word to the wise. You can send your drivers after May 1st. Many supervisors have learned a hard lesson, and that is to wait until the day after school's out. If you send a bus driver back for their physical in May, and they have high blood pressure and they fail their physical, they're done driving. they can't finish the school year, because once that physical is taken, you can't say, well, this doesn't apply until next year. No, once they fail that physical, that takes place immediately. And so bus drivers, a lot of bus drivers tend to have blood pressure issues, and especially at the end of the school year when they're tired, the heat's coming up in the bus, kids are getting on their every last nerve. You don't want to set yourself up for a failure by sending all your bus drivers for their physicals on May 10th, and then on May 12th, you don't have enough drivers to cover the routes. So you might want to wait until the day after school is out to send them for their physicals. All right, so where do you get the physical forms? You download them. They know ODE no longer prints them. You have to download them from ODE's website. You send those forms to the examiner, and then you have to instruct the examiner to fill them out correctly and return them directly to you. It is not acceptable for them to hand that form to the driver and let them carry it back to you. Think about this. If there's blanks left on the form, or maybe a driver failed, this is all chain of custody thing. So the documents that are filled out by the examiner have to be returned directly to the district. And you also need to tell your examiners they can't change the forms. We've had cases over the years where doctors drew a line through some requirements and wrote their own requirements in. They don't have that option. The elements that are being tested on the physical are actually part of administrative code. They can only be changed through a change to administrative code. Doctors can't adjust those things of their own volition. So important note, the T8 physical does not include a drug test. There is a urine test, and that's for glucosuria, but there is no drug test included in the physical. Now, some school districts choose to add that. You can do that, but it's not a state requirement. And there's a couple of cases where physicals can have what are called conditional passes, especially with regard to blood pressure. There's 3 blood pressure ranges. There's a passing range, there's a failing range, and then there's a window in the middle. Some of your drivers will come back having been in that marginal range. What happens is they get a conditional pass, so that's good for 90 days. Their blood pressure has to be rechecked at 90 days, and it has to be passing then, and it has to be rechecked again at 6 months, and it has to be passing then. So here's the thing, conditional only happens once. And then the next 2 checks, they have to pass their blood pressure reading, or else they're done driving a bus. And then the other test is the glucosuria screening. And so if they find sugar issues when they do that screening, the doctors doing the T8 may say to an individual, we want an additional workup to be done by your own physician and get back to us with the results from that. So here's this whole thing with diabetes, and I just want to clear it up. There are some individuals in the world that have diabetes and it's controlled by means other than insulin, and that's okay. So they don't have to do anything special. We run into a unique scenario though. Anybody that is insulin dependent to manage their diabetes is required to apply for a waiver with ODE. There's a lot of steps involved in that. It's not the simplest process in the world. It's a driver's responsibility to do this. You may want to help them, but at the end of the day, make it very clear to the driver that it's their responsibility to do this. And then if a waiver is granted, it does require periodic updates with ODE to remain valid. So, for example, every 6 months, they have to do an update with ODE. And then also, anytime they have a crash or a ticket, whether it's in the bus, car, or anything else, they have to notify ODE. And if they don't, it's an automatic cancellation of their waiver. And so make it real clear to any driver you've got who's insulin dependent and that needs this waiver, make it real clear to them that it's their job to keep up with all this, not yours. You're welcome to help them, but at the end of the day, if they miss a step and they're no longer eligible, you don't want to set yourself up for failure by letting them grieve you because you didn't do it for them. This is the driver's responsibility. There's a couple administrative things on the physical that I want to touch base on here, and that is, as an employer, you can send a driver for a new T8 test anytime you want to. We specifically wrote that into the code, so that is your prerogative. So here's what happens if a driver is disqualified. In other words, if they fail their T8. and there's some, this kind of goes back to what Van was talking about. There's deadlines and things that have to be done in writing. Very important, folks. So you need to notify the driver in writing within 15 days. So when you open that mail and you get a T8 back on a driver and the physician has failed them, you need to notify that driver in writing within 15 days that they failed their T8. The driver then has the opportunity to request an appeal within 15 days. So what an appeal is if they ask you, I want to appeal my T8, you need to send them for a new T8 exam. So you would send them to a different individual, could be the same medical practice, but it just needs to be a different individual. And they go for a new T8. And what the code says is the results of this re-examination are final. So this is not Stanley Cup where they can keep going until they pass, right? If they fail the second exam, they're done. And as an employer, your duties have been discharged. You would release them from employment and they're on their own. You do need to enter that failure into SFPS so that it becomes a part of their record. Now, this sounds really cold-hearted and cut and dry, and yes, it is. But let me say this to you. If you have a driver who fails their physical because of high blood pressure, and that's a particularly valued employee, and it's hard for any of us to lose bus drivers in this day and age. Maybe what you do is you sit down with the driver and you say, okay, here's your written notice. You did fail your T8, so make sure you don't overlook that written notice. But maybe what you want to say to the driver is, we'll send you for another T8, and let you try this again. But how about you consider working with your personal physician to get your health under control, get your blood pressure under control. We don't want to set you up for failure because now the stress is really on. But take whatever time you need, whether you want to give them a month, 2 months, 3 months, let them get their blood pressure under control. And then when they're ready, let them come back to you and say, okay, I would like to try for a T8 again. That's an option. So you can go hardline on this. You can follow the 15-day sequence, send them, find them disqualified, or you can take one step further and work with them. Here's a case where you want to make sure the superintendent's involved, business manager, personnel involved, and it might be smart to get your district's personnel attorneys involved just so that everybody's on the same page. You don't have to be a hardball on this. The code is set up so that there is a process, but you do have an option.
There's a good question in chat, the last question in chat.
Okay. The one on major offenses?
The one on how do we know if a waiver is no longer valid?
I don't see that.
It came to me, but
okay.
I thought that was a good question for you to answer for everyone.
Okay. Insulin waivers, if something happens and a driver becomes disqualified, they failed to renew something, ODE will notify the driver, but will also show up in SFPS. So any changes to a driver's qualifications are always going to show up in SFPS. And the way we engineered that system when we built it back in 2003 is that if a driver changes from what we call active to inactive, that will trigger an email to the administrators in the district that are registered with SFPS. So what I always recommended when I was setting this up and teaching supervisors is set up a dedicated mailbox in your system and set up a rule so that anything that comes from SFPS automatically goes there. And first thing every morning when you show up at work, turn on that email thing and check that box and make sure that you didn't get any disqualification notices for any of your drivers, because that's how you'll know what's going on. All right, let's talk about the training rule. Oh, I know what I was going to say. The districts have to pay for the physicals. All right, so know that it is your responsibility to, and I know everybody has different negotiated agreements. In some places, districts pay for training, some places drivers pay for training, but the law hard codes this as physical costs are the responsibility of the employer or school bus owner. All right, so let's talk about the training rule. The bottom line is, in the training rule is where we talk in detail about the training certificate, in other words, the T9. So what it says is all drivers are required to complete ODE's pre-service driver training program. So know that this is a closed system. Even a school bus driver that moves in from Kentucky and they say, I've been driving school bus for 100 years in Kentucky, well, maybe only 20 years in Kentucky, and they want to work for you, they have to go through ODE's pre-service driver training program. And that's just the way it is. There's no waiver, there's no challenge system. Perhaps there should be, but I'm only going to talk about what we have right now. And so anybody coming into the state of Ohio to drive a school bus has to have a T9 certificate. And the way you get that first time through is you have to take a full classroom course, which is 15 hours. Now, important sidebar here, all these classroom courses got stopped back in March. We had legislative intervention that required ODE to implement an online alternative. There was a deadline in the statute for them to do that. That deadline is passed. We've not seen anything about the program. So we have flagged this to the attention of some folks trying to find out what's going on. We're still waiting for that. But the requirements as they exist right now is there's a 15 hours worth of classroom. Then there's a behind the wheel component, which is a minimum of 12 hours. And then there's an element where that candidate needs to observe a route. In other words, ride on a route with a current driver. And then they have to drive a route under supervision. And so obviously they want to do that after all their training is done, so that they're coming to the table with all their skills. Let's see. Does anyone know of a trainer to be willing to come to our county and provide pre-service training in the evening? So Sue Ellen, what I'm going to say to you, you're probably looking for an OBI. If you go onto ODE's website, you can actually pull a list of all the OBIs in the state, and there's nothing wrong with borrowing OBIs from other districts. We have some districts in the state that don't even have their own OBI. In some cases, they have an OBI, but the OBI is not available. And then in some cases, there are personality conflicts, and you'd be better off to have someone else work with them. So feel free to call around, ask other supervisors, and see if they've got someone available that'd be interesting to work with you. All right, next slide. Oh, for the 4-day pre-service class, right now, so the question is, who can do the 4-day pre-service class? And the answer to that is, right now, that can only be taught by ODE's pre-service instructors. And just a note on the structure of that program, pre-service is an ODE program. They contract that out. And so those pre-service instructors actually, they are teaching ODE's program, but they work for, in almost all cases, an ESC. In one case, they work for a vocational system. So they're actually employees of a local entity, either an ESC or a JVS, but it is ODE's program. And again, the law that was passed said ODE needs to come up with an online component for both the certification and the recertification. That'll help take the pressure off some of these folks that need to do this training but can't take off work to do the training. So we're hoping we can get that problem cleared up very quickly. So here's what it takes to get a pre-service certificate. You have to complete all the elements within 12 months. So there's some cases where drivers have taken longer than 12 months to get the different parts done. And what happens is the oldest thing has to be redone. That then fills, you get a completed T9 report, and as a supervisor in the office, you submit all that information to ODE. You do that through SFPS. The pre-service instructor for your region has access to those records, and either they or ODE staff will approve that T9 if all the parts are in order. And the essence of it is that pre-service instructor needs to verify that the driver really attended a class. Question, can drivers go to a pre-service class in another region? Absolutely, yes. Pre-service is supposed to be the same regardless of where you take it in Ohio. So these certificates are valid for 6 years, and they have to have a valid certificate. There is an option in law. ODE had proposed removing this. We pushed back pretty hard, so it's still in law, that says drivers can get a temporary certificate. Now so here's the meat of the discussion. If you have a driver, the OBI's done all the work, they've got their CDL, everything's in place, but they haven't been able to take a classroom training. Does that mean you can't use them? Well, if you read the law strictly, it says yes. So what's in place is that ODE can waive the classroom portion for up to 45 days for first-time trainees. Now, that's probably not the best scenario. The better scenario would be that they get this online thing done so the drivers can do it online and get it done. But if a driver can't get to a class, you could tell your OBI, well, train this driver in all these policies and procedures. And then with that temporary certificate, you can put them to work immediately pending the completion of their of their class. Just be aware that if you do this as the employer, you're assuming the responsibility of providing all the training. In the interim, the driver is still responsible for all compliance with all regs. Now, here's the thing I wanted to say. If we go back one slide, when we talk about all the elements must be completed with 12 months, this is not including CDL. So CDL is actually a separate thing. For convenience, the pre-service instructors also teach CDL skills. But I just want to point out to you, especially with the pandemic issues, if you have a driver that got a CDL temporary permit and they got it before March, it actually remains valid until the end of December. FMCSA has said that all CDLs, all temporary permits, all the expirations on those things that would have occurred after March are deferred until December the 31st. So if you have someone that's got a CDL temp permit and it looks like it's expired, but that expiration date happened after March, it's not expired. And we just had a case where I had to help a district that had a problem with a local registrar, local testing station, and we intervened. And so yes, those drivers with those temp permits can go in and test for their CDL. All right, and then every 6 years, a driver has to renew their expiration. Again, they have a 12-month window to complete it. The classroom portion for the renewal is 9 hours. Usually that's a 3-day class. Again, we're waiting for the online alternative pending. And then the other thing is that the drivers have to have an evaluation by an OBI. And what the law says is they get up to 4 attempts to pass that thing. Now, I've been hearing some feedback from the field about OBI instructions on these tests. So I just want to clarify a point here. OBIs work for you. They are your employees, and so you direct their work. They are certified as an OBI by a pre-service instructor. So if you have a driver who is due for their recertification and you decide locally that the smartest thing to do would be to send the OBI with them, maybe to observe them on a route, or maybe to take them out one day and make sure their skills are up to date, that's your call. Both those individuals work for you. If you want them to do that, then there is nothing in the law that prevents you from doing that. And the reason I bring this up is I heard in possibly in one region, OBIs were being told they're not allowed to train someone before they test them. And I can understand on the day that the OBI is going out to do the evaluation, you can't coach them so that they pass. I mean, they need to drive the exam and pass it. But if you want to say to the OBI and the driver, you guys work a couple of days ahead of time, let's make sure you're up to speed on all the most recent teaching techniques and everything, they're your employees. You have the right to do that. There's an alternative for the certificate renewal, and this has been in place for quite a while. A driver can renew their certificate if in the last 24 months they participated in one of the state's rodeos and they got at least 80% of the possible score. Or they can waive the classroom portion, the 9 hours, if they attended an advanced school bus driver training program. So again, if they've done either of those in the last 24 months, the rodeo participation waives the driving evaluation, and the advanced school bus driver training program waives the classroom portion. Also in Rule 10, we have an annual in-service requirement. And this one is kind of taken some new turns this year for us with COVID and the problem with in-person stuff. What the law says is that as an employer, you have to require all drivers to attend annual in-service training, and that's 4 hours minimum. So you can do that in one shot, or you can spread it out over a bunch of sessions. My inclination is to spread this out in multiple sessions. Unlike an MTA class, we know that it's best not to try to train bus drivers for 4 hours straight because you lose their attention, and I'm probably losing some of your attention also. And I apologize for doing these long classes, but it's when we can get together. But for bus drivers, it might be smarter to do, maybe a half-hour training session once a month all year long. It is acceptable this year to do virtual or computer-based trainings, so there's nothing wrong with that. As an employer, you need to keep track of the curriculum and also keep attendance records. So a little bit back on the onboard instructors, I think I already covered these points. They work for you. They're certified by a pre-service instructor. There are additional trainings that they're required to go to. And I would encourage you as a supervisor, coordinator, director, whatever your title might be, to think about your OBIs as a great resource. As a supervisor, you have a lot on your plate. And it's really hard to get hands-on and do everything. And I know a lot of supervisors really like to keep their OBI status, but at the end of the day, you're really, really busy. And so you might want to think about saying to the OBI, when you go to your trainings and when you're keeping up with the latest teaching techniques, maybe periodically you could go out with drivers and just give them tune-up tips and help them understand what's best practice currently. And that's a powerful resource for you in the district, and one that could take some important stuff off your plate and maybe help you to be more effective as a supervisor. All right, here's a slide with a small print, and I'm not even going to try and read this to you. I included this in the PowerPoint. We're moving into the criminal background checks. This used to be printed in Rule 23. It is no longer. It's taken out, and that's okay. I understand why ODE took it out. But if anybody ever says to you, what's the history of criminal background checks for drivers? Why do we do it? Here it is. You have it on this one page. Just know that this general notion goes all the way back to 1984. So criminal background checks for drivers are not new. What has happened is we got into this time period between 2007, 2010, where we had some unfortunate incidents in the field that kind of forced us to step up our game. And so that leads us now to this new Rule 23. And so let's talk about what goes on in the criminal background checks. Know that if you recall, they're mandated in 3327.10, so we have to do them. You have to do a pre-employment check. You have to get the results back before you hire them. You're not allowed to hire conditionally pending the results. So you have to have the results back. If you don't have them back, you can't hire them. So you have to do a state check. You have to do a federal check. We already talked about the waiver. You might choose to still do the federal check. They have to be done again every time a driver recertifies. And again, state and FBI, you could waive the FBI if you wanted to, or you can leave it in there if you want to. Now, you don't have to wait till 6 years. You can do this sooner. There's an incongruity in the law. Every other school district employee has their background checks done every 5 years. We do ours every 6 years. The reason for that is this whole thing came about for school bus drivers first. We set the code up, and then they rolled out the teachers and the other employees a couple of years later. And I said to them at the time as a state administrator, we just figured this out. Don't make us change this again. And so they left the bus drivers on a 6-year cycle. Everybody else is on a 5-year cycle. So the only problem that will be for you is if you have a bus driver who's also a custodian or maybe a classroom aide or has another role in the district, so that now they have a 5-year requirement and a 6-year requirement. In that case, I would encourage you to just have them recertify their bus driver certificate at 5 years instead of 6 years. If you look at cost management, sometimes these background checks cost more than anything else. Instead of doing one at 5 years and another one a year later for the 6-year thing, just do them all together and then do it at that 5-year cycle and have them recertify as a school bus driver on the 5-year cycle. There's nothing wrong with sending a driver early. Can safe school training be considered when it is not an unusual year like this year? Lisa, I'm not sure I understand your question. If you want to undo your mic and ask me, and I'll try to answer that one for you.
When we're doing our in-service trainings, can you use safe school training, which would be an online courses?
Oh, sure.
Okay.
Yeah. So you get to pick the subjects of the in-service training every year. And so there's a list of things in the administrative code, but it's not a closed list. You can do anything that you think is appropriate. There's some great online resources out there, and maybe you have the drivers do some of those things on their own time, and get some of that done that way. There's some crisis intervention training that can be done online. Probably one of the things that's easiest to do online instead of wasting group time on it is personal protective equipment and some of the OSHA trainings. So yeah, you can, anything that you think is appropriate, whether it's online, in person, remote, that's fair game. I will say here that I know of cases where bus drivers have come back to their supervisor and say, hey, I just did this, that counts. I don't have to come to your in-service training. You get to decide what counts, not them. So, maybe they did something to better themselves, and that's okay. And you can honor it, but you can also say to them, well, that's good, but you still need to go through our in-service training where we talk about administrative procedures. So at the end of the day, you're in the driver's seat on this. Just keep good records. All right, so here's this whole thing with the records check. There is a list of disqualifying offenses. And what the law says is two things. First off, if anybody is arrested, summoned, or indicted for an alleged violation, they're no longer allowed to work in a position that requires care, custody, or control of a child. So, you know, we're all used to in this country thinking, well, you're innocent until you're proven guilty, and proven guilty means you've been convicted. Well, the way they set up this code, and this was the legislature's doing, is that if you're arrested or charged with one of these disqualifying offenses, you can no longer be in a position where you have control over a child. So it's immediate. It's immediate. So what that means to you as an employer is you have to put them on leave. And they're no longer allowed to do that job where they have interaction with students. Now, you don't have to terminate them. You don't have to release them from employment until this whole thing adjudicates. And if they're found guilty, then they're done. If they're found innocent, you can put them back to work. And I'm not going to even go into the whole subject about do you pay them? Do you reimburse them? That's a question for the Van Keatings of the world and your legal attorneys. But I will say to you that while the cases are pending, you can't use them. So you have to put them on leave. If they are acquitted, then you can put them back to work immediately. If they are found guilty, they're done. They're no longer an employee. So what's in the code, and I've given you the codes, it's all text. What I've also provided for you in our handout section is a chart. And ODE no longer provides us as a chart thing. It's about 4 pages long. I've just pulled up 1 page of it here. I would encourage you to print out that disqualification chart, the complete thing that I've posted in our MTA resources library, because I think it's a lot easier to keep track of. And so what I've done here is just printed the 1 page of it. So just let me walk through this for you. In the first column, it talks about this is the actual number of the code, and it's grouped. So what we're looking here is major motor vehicle offenses. There's another one for felonies, another one for sex crimes, another one for drug crimes. Here you get the code. In the excuse me, in the second column is when this particular requirement was added to the disqualifiers. Third column, you see a description of the code. And then in fact, final column tells you how long this disqualification extends for. So what this means is, in this case, somebody who's convicted of 451119 may not drive a school bus for 10 years. Here you can see if they were charged with 4511-194, which is physical control under influence. By the way, this is one of the biggest plea downs to an OVI. So here in this case, if they plea it down and the court says, okay, we'll convict you of this instead of OVI, they're disqualified for 6 years. Down here, you see these 1-year things that we talked about earlier in Rule 6, 451175, that's school bus lights. So whether they're in their personal car or a school bus or anything, if they run a school bus's red lights, they can't be considered for reemployment until after 1 year. Here's the school zone speed limit. Here's a railroad crossing violation. Right. So look at this chart. Absolutely, you can use the language that's printed in 23. I've given that to you. I find it a lot easier to read the chart, and that's usually what I send out to folks when we have questions about this. So what do? You find out somebody has been charged with something, you need to immediately suspend them. All of the codes listed in there constitute a disqualification. So anything that's listed in these charts means that driver is disqualified. In some cases, the employer can consider rehabilitation. So if we go back to this previous chart, somebody's charged and found guilty of reckless op, that means you have to let them go. After 6 years, you are allowed to consider them for reemployment only if you can mitigate the risk of it happening again. So what they want you to do is they want you to consider rehabilitation. And this is spelled out. There's a bunch of steps. It's spelled out in the administrative code. So if you decide to go through that process with a driver and you want to consider them for rehabilitation and you meet all those steps, you can bring that driver back. But what I want you to know and to remember, and the drivers don't always get this, is that rehabilitation is unique to an individual employer. So if you decide after running somebody's record that you want to consider them for reemployment after they're eligible for doing that, you can do that. But just because you bring them back doesn't mean that another employer has to bring them back. So every employer gets to make their own decision on rehabilitation. I'll tell you up front, this is a tough standard. And we've lost a number of bus drivers through here. Ohio standards are tough. There are those that correctly have assessed that you could probably be a president of the United States, but not a school bus driver in the state of Ohio. That indeed is the truth right now. We've had a couple of presidents that would not qualify under our rules. And so the standards are pretty high. The bar is really high. That's particularly challenging for us right now when there's a shortage of school bus drivers. There are some that argue we should relax the bar, and maybe we should. We won't have that political debate here in this venue, but we will talk about what the regulations are right now so that we all know what we have to manage right now. Covered a lot of territory today. We talked about a bunch of legal codes. We talked about drug and alcohol. We talked about some written resources. We talked about the laws. Here's some resources that I want you to think about. As a district, every district has a policy manual. Make sure you're familiar with the transportation sections in there. Every district should have a driver handbook. Not all do. And we talked about that a little bit earlier. We got a class coming up in February where we're going to deal with the driver handbook. It's a valuable tool. You should think about having one. If you have a union contract, you need to be very familiar with the negotiated agreement, know what's in there. Know if there's some clarifiers in there. One of the superintendents that's on with us today posted a chat earlier saying that in their negotiated agreements, every time they renegotiate, they have a statement in there that says, if it's not in the agreement, it's not in force. And you know, that's a very clean way of managing some of the difficult things that Van was speaking about with regard to past practices. So those are the kinds of things to think about. Hopefully these classes are learning opportunities for you, not only the material that we present, but the information and the material you can get from the other folks in the class. You know, we got 80 people involved in the MTA program, and some of those people have walked some of these paths and some haven't. And so feel free to reach out not only to us at OSBA if you have questions, but also to other folks in the MTA program. And there's always some great wisdom out there from folks that have figured out how to do something. You know, I've said for a long time, going on my 43rd year in this business, and I've come to the conclusion that pretty much all the problems are the same. They just have different names in different districts. They just keep recycling and coming back up. So we're more than happy to help you out, but we're also more than happy to say there's some other folks out there that are very skilled and experienced in doing these things also. And the peer network is very, very important in this business.